Hey, what's up, everybody? So, this is a long overdue video. Some time ago, I was on Twitter and I got this information from a court reporter, and it seemed really interesting. So, I thought I would make a video on it, right? And essentially, what I'm seeing is that the federal government, or just the government in general, right, be it state or municipality or federal government, they're coming out and they're starting to punish the rioters. Now, I'm kind of torn on this, and the reason that I'm torn is because I really don't believe there would have been any substantial change without the rioting. I say this because people have been peacefully marching for a century and very little has changed. Well, I guess that's unfair for me to say. There has been steady change, but there hasn't been a change that would bring finality to all of this. And so, with that said, it's hard to believe that people should be punished for rioting. And there's also the other dynamic because we saw police officers essentially commit crimes as well, right? And it's like they're allowed to get away with some of these crimes because they're police officers, right? And I guess I should be fair. Some police officers are actually being held accountable, but there's some that are not, right? So I'm a little, I guess I'm a little confused on who should be punished and who should not be punished. Leave your questions, comments below, and let me know what you think on whether or not the rioters should be charged and indicted. Leave your question and comments below on whether or not you think police officers should be charged and indicted, because there were video of police officers running over peaceful protesters. Of course, there's a one video out there where the police officers shove an elderly man and he falls down and he hits his head and he starts bleeding out of the ear. So there's misconduct on both sides. There's misconduct on the government side, which is represented by the police officers, and there's misconduct by the rioters because they were rioting, right? And there has been some arguments made to say that there were the people who were protesting peacefully and those people should be excluded from the rioters. I'm not sure I would buy an argument like that because, again, I don't think peaceful protest would have made a difference. But, that's not what this video is about. Leave your questions and comments below and let me know what your thoughts are as far as would there be change without rioting, right? So I'm interested in hearing what you think about that. So anyway, this video is about the government prosecuting people for rioting. So one of the persons, so this is actually in Illinois, United States District Court, Northern District of Illinois, Eastern Division, and it's the United States of America versus Brandon Peggs, right? And this indictment is based on Title 18, United States Code, Section 922G1. And basically, they give you part of the statute, or at least the relevant parts, and they say, knowing that he had previously been convicted of a crime punishable by a term of imprisonment exceeding 1 year, did knowingly possess in and affecting interstate commerce a firearm, namely a loaded Glock model 19 9mm semi-automatic pistol bearing serial number SHA 45, which firearms had traveled in interstate and foreign commerce prior to the defendant's possession of the firearm. So, from my understanding, I did go and read the entire statute. This is only a part of the statute. From my understanding, is that they're saying that he had been convicted of a crime in the past, and because he was convicted of a crime in the past, he was not allowed to have a weapon that was from out of state. That's essentially what this is saying, in my opinion. Leave your questions and comments below if you have a different interpretation of this. I actually did read the entire statute. It's long, it's beefy. I'm not going to go through all that in this video. I'm going to try to make this video as short as possible, right? So the arresting, not the arresting officer, but the person who did the investigation is Cindy M. Byrne. I hope I'm pronouncing her name right. But she's a special agent with the Bureau of ATF, alcohol, tobacco, and firearms and explosives, right? So the story on this is that the Chicago Police Department officers were in the vicinity of 801 South Financial Place in Chicago in response to a mass crowd and multiple report ongoing crimes, including criminal damage to property. Officers observed four men running southbound on South Financial Place, some of whom were carrying hammers, right? So officers relocated to 801 South Financial Place to investigate further. Officers observed the individual, later identified as Pegasus, look at them and adjust the right side of his waistband and then flee southbound on South Financial Place, right? Chicago police officers pursued Pegasus on foot. As he ran, Pegasus stumbled and fell while reaching in his waistband. Officers observed a firearm fall into the ground and further observed that Pegasus pushed the firearm along the ground under a vehicle. CPT officers apprehended Pegasus. A CPT officer recovered the firearm from underneath the vehicle. The firearm was determined to be a Glock model 19 9mm semi-automatic pistol bearing serial number SH485. The firearm was loaded, right? So now they get in. So that's the story. Long story, dull. He was downtown and the cops were investigating riots and they basically saw him. He looked suspicious. He made a run for it. He dropped the gun and then he pushed it under a vehicle. They grabbed him. They grabbed the gun, right? So now they get into his criminal history and they say, I know that on or about January 14th, 2010, Pegasus was convicted of residential burglary, a felony in the Circuit Court of Cook County, case number blah, 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 for which he was sentenced to 30 months on probation, right? And then that's what he did. He was a burglar, and now they get into the interstate with the actual law, right? Based upon his training experience and the years and the research he conducted, Special Agent McBride determined that this Glock 19 9mm pistol was manufactured outside the state of Illinois. Therefore, in order for the foregoing firearm to have been recovered in Illinois, it had to have been moved in interstate or foreign commerce. And that's essentially it, right? So they're charging this guy not with the fact that he had a gun, right? Which is kind of an interesting dynamic. I believe what's happened is that there's multiple charges against this guy. So actually, we should go and see if we can find an arrest profile on the Chicago Police website. So let's go ahead and do that now, and then we'll talk about this as we do that. So since this arrest was made by the Chicago Police Department, I've gone to public search one at chicagopolice.org. And so the URL is right there if you want to pause the video, if you ever want to do an investigation on arrest in Chicago, that's where you would go. And I'm just going to do an arrest search, right? And I have to tell it I'm not a robot, which I'm not. And I'm just going to plug his name in. His first name is Brandon and the last name is Pegs. Now, this site I notice is really difficult to use. Sometimes you have to be very specific. You can't make kind of a general search sometimes. But anyway, let's see what we get back. So this is what comes back. And if we click on it, we find this young man, right? Brandon G. Pegs, age 28. And I don't know what this CB number is. Maybe if you guys know, please leave your questions and comments below and let us know what this CB number is. And essentially, the arrest is for weapon, felony, possession, use of firearms, right? offense as cited, right? Now, I can go and look this statute up, but I'm going to pass on that for now because we can kind of almost guess what it is. He was caught with a firearm, and that's what they arrested him for. Um, if you want me to look up that statute, leave your questions below, your comments below, and then if I get enough people that are interested, I'll look it up. But it's a firearm. So here's the thing. Here's the thing. So the thing that troubles me about this, and I'm torn. I'm really torn, right? Because I think one of the reasons that they have laws like this is because actually, you know what? Let's go and skim the statute. Let's just go ahead and skim the statute before I get into any commentary. So what's happening here is that he is being hit with the federal statute, which we already have a glimpse of, and then he's also hit with an Illinois statute, right? So he's being hit and on two different levels, right? So now I'm going to give a teaser here because I'm working on another video which is going to get into double jeopardy. And you guys should take note that he's being charged both by the city of Chicago, right, or the state of Illinois, as well as the federal government. So he's having to go to two different courts, right? So this is going to be important because we're going to get into something in another video series called the dual sovereign doctrine, which basically says that two kings can try you for essentially the same crime if they have laws against it. And we're going to talk about how that plays against double jeopardy, right? So, at any rate, let's go ahead and take a look at the state statute. Okay, so the statute, well, here's a statute right here, and basically this is 720 ILCS 524, and it's basically unlawful use or possession of weapons by felons or persons in the custody of the Department of Corrections, right? And the particular section which he's being charged with is here. It is unlawful for a person to knowingly possess on or about his person or on his land or in his own abode or fixed place of business any weapon prohibited under section 24-1 of this act or any firearm ammunition if he has been convicted of a felony under the laws of this state or any other jurisdiction. This section shall not apply if the person has been granted relief by the Director of the Department of State Police under Section 10 of the Firearms Owners Identification Card Act. So it looks like, it's obvious that this was a state charge for felon possession of possessing a firearm. But it's interesting to see that you can still get a firearm if you get a gun card, right? So it looks like it doesn't matter whether or not you're a felon, you can still possess a firearm so long as you have a gun card, right? So that's the gist of these charges. Now, again, just to recap, he's being charged in the by the federal government in federal court, and he's also being charged on the state level by the state court, right? By the state prosecutors, right? So one would think that there could be some double jeopardy going on here. And I'm not going to get into that issue. I'm just going to leave that aside because I have another video which I'm working on. It's overdue, as a matter of fact, but it's going to get into double jeopardy issues, right? So I'm not going to get into that now, right? So here's the thing. One of the questions came to mind, or one of the issues that popped up in my mind, is whether or not the search was lawful. Now, we all read the indictment, the federal indictment. We didn't read any indictment from the state court, but we read the federal indictment. And basically, the federal indictment says that the guy tried to make a run for it, and he basically fell. And when he fell, the gun fell out, and then he shoved the gun under the car, right? So one question or one issue that pops up in my mind is, what if the police are lying, right? What if the police are lying and they actually arrested him first, and during the arrest or they tried to arrest him first, and during the attempt to arrest he ran, right? What if that was the case, right? So if that's the case, and we all know people lie, police officers are people too. And I'm not saying that they did lie, but I'm just thinking of ways that, this guy could, possibly defend himself. And maybe he doesn't need to be to defend himself. Maybe he just needs to admit to guilt and go to jail. Leave your questions and comments below. But as you know, I always like to play devil's advocate here. So what if the police are lying? What if they arrested him first? If they arrested him first, then that would basically constitute an unlawful search and seizure. And if it was an unlawful search and seizure, then the gun charge has to go away, right? And the case law that I found behind this is that the Fourth Amendment to the United States Constitution guarantees the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures. And then reasonable seizures under the Fourth Amendment, I'm sorry, reasonableness under the Fourth Amendment generally requires a warrant supported by probable cause. And then it goes on, the Supreme Court recognizes a limited exception to the traditional search warrant requirement in this particular case, Terry v. Ohio. Under the Terry exception, a police officer may briefly stop a person for temporary questioning if the officer reasonably believes a person has committed or is about to commit a crime, right? So if they're lying, and if they basically tried to arrest him or they tried to detain him, then they would have to basically explain why they thought he was about to commit a crime or he did commit a crime, right? So that's one of the possible defenses that this guy could have if the police is lying about the arrest. But I mean, obviously, if they're not lying, then they have to look at other possible defenses, right? And even still, even if they are lying, right, it still becomes difficult because they can still claim that there was a probable cause. The probable cause are the riots, and they're likely to say that people were rioting in this area, and when we came on the scene we saw all these broken windows, so on and so forth, and we saw this guy. He looked suspicious. He looked like he had just broken a window or something along those lines. I mean, they don't even necessarily need to say that he looked like he broke the window, but I guess probable cause would be enough if there was a broken window or there was property damage near to where they found him. So even if they were lying, it would still be an uphill battle because they can just simply det- detain him, right, or briefly stop him if they believe that he was rioting, right? So I don't know. I mean, it doesn't look good for this guy. Now, I don't know if I actually have the penalties for this thing, but basically, the penalties are looking pretty stiff, right? I think in one case I read they were talking about 12 years, right? Yeah, so uh, a Class X felon, if he possesses any firearm, fire ammunition, or explosive, or Class X felony for which the offender shall be sentenced to not less than 12 years. So this guy is looking at and not more than 50 years, right? Oh man, that is horrible. So you know what? I'm actually taking this out of context because there are different classes of the felony, right? So it depends on which one he fits in. I'm not going to go through all this, but he's potentially looking at some substantial time just for having a weapon, just for being a convicted criminal and having a weapon that was in his possession. Now, there's other possible defenses that he could use, but I wasn't there. I don't know all the details of the case. And first off, and I should have said this earlier, I'm not a lawyer. I'm just some guy on the internet reading legal documents. So take what I say with a cup of salt, not a grain of salt, but a cup of salt, because I'm just reading this stuff on the internet. I don't have any legal training or experience, right? But with that said, there are other defenses that he could possibly use, right? So you guys read, well, actually, let me go back and I'll read it again. So going back to the criminal indictment, the federal criminal indictment. Now, of course, this is the federal indictment, but the last thing that we looked at was the Illinois charges. But I'm just going to get to this point, right? So both of these indictments are depending upon one critical thing, and that's whether or not he was a criminal in the past, right? So basically, if I were him, if I was in his shoes, I would go back and look at the previous conviction. I would go back and I would try to vacate the previous conviction. And there's lots of possible ways to vacate an old conviction. And I'm not going to get into that now, but I have a video which kind of touches on this subject. And I'm planning to make a video on how to vacate a conviction or a judgment against you, right? So, but let's look at the previous conviction, right? The previous conviction says that on or about January 14th, 2010, Peggs was convicted of residential burglary, a felony in the Circuit Court of Cook County, and then they give the case number, for which he was sentenced for 30 months in prison. I'm sorry, 30 months on probation. I'm sorry, 30 months on probation, right? So here's the thing. Very rarely do you get caught in the commission of a crime and then they just give you probation. So one of the things that possibly could have happened here is that there was a plea deal. There was some sort of plea deal in which he probably agreed to admit guilt and they just gave him probation instead of jail time, right? So I don't know that's this case. If that's the case, I'm just fantasizing here. I don't know if that was the situation, but to me, it looks like it could be the situation. Because otherwise they would have gave him some time in jail, and then he would have got probation after he served his time. So I'm willing to believe that there was a plea deal, and if I were him, if I was in his shoes, I would be trying to go back, look at that judgment, and find a way to vacate it, right? So just to let you know, there's no statute of limitations on fraud. So if there was some type of fraud involved in the judgment against him, which made him a convict, then he can have it thrown out, right? So if he has it thrown out, then he no longer is a felon. If he's no longer a felon, then they can't convict him on the state or the federal statute. So whether or not whether or not he has a strong chance, if he has a 5%, a 0.005% chance on getting that old judgment thrown out, he has to take it, because it's probably one of the best ways to, get rid of all these charges against him, right? Another possible way that he could probably deal with these charges is to look into the constitutionality of these charges. Now, and that's probably why they're charging him twice, right? Because the Constitution has a stipulation that basically says everyone has a right to bear arms. And the particular statutes that we're looking at are targeted towards felons. The statutes are targeted towards felons. So he could possibly make an argument, right? He could possibly make an argument. There's lots of research, legal research needed to make an argument. But he could possibly make an argument to say that, these statutes are unconstitutional. I have a basic fundamental right to bear arms. Now, just to give you a little backstory, so before nobody could bear arms or no one could have a handgun in the state or in Chicago. And that statute has long since been held unconstitutional. So, that caused a lot of rewriting of several statutes. And I think even this particular statute, or at least the state statute, was unconstitutional at one point, but it was rewritten. And I want you to notice that when we read the state statute, it specifically said that you can be relieved or it can be a defense of this crime if you were given permission by the state police or something like that, right? So, constitutionality is a possible defense. That's something that I would look into if I was him, right? And so I mean, he has to take every chance he can to basically save himself because he's probably looking at some serious time. Once he does the state time, then he's probably going to be transferred over to the Fed so he can do Fed time. It's just kind of it's not looking good for him now. I'm kind of torn on this because on one hand, I think they're really just trying to punish the rioters and the protesters, and I definitely think the protests needed to happen. And I don't think the protests would have been effective without the rioting. That's just my own personal opinion. Again, let me know if you think differently. But they're basically punishing the rioters, right? And they're looking, to me, it just seems like they're looking for the worst of the worst to punish because I don't think that it's going to be effective to punish someone without a criminal background who was protesting if they catch a person like that. And let's say the person like that threw a water bottle or something like that and it hit a cop car, right? I don't think that they're going to be able to prosecute a person like that. They are not going to be able to have success if a person like that doesn't have a criminal background. Then they ask for a trial by jury, and a jury is not going to convict them. And of course, that could be another possible defense for him. He could just simply ask for a trial by jury, right? And as we all know, a jury has the power of jury nullification, right? It's not a right that an individual has to ask for uh, something called nullification, which is basically saying that the jury believes a person is guilty, but they're saying, you know what, we don't care about that law. We don't care about that law, so we're going to set them free. So the jury has this power, and it's kind of funny, but this power goes back way back to the king's times, right? The time before a law was even established in the United States, right? So the jury has the power to say, you know what, he's guilty, but we're not going to convict him. And that's something that's probable, that's as likely to happen because the jury, they could make the argument that, well, he can make the argument, Pegs can make the argument that, he was fighting, he was a freedom fighter. He was out trying to bring about change against social injustice, right? And if he gets the right jury, this could be a possible defense, right? Leave your question in the comments below and let me know what you think about that. Would you, if you were on the jury, would you let this guy go because he was simply participating in the riots and he was basically trying to bring about change against racism? Would you let him go? Let me know, right? But that's it for this video. So these are all the possible defenses that I can think of. Basically, attack the constitutionality of these statutes, which, and none of these defenses are going to be easy, right? And to be honest with you, they are probably not strong defenses, right? I mean, but hey, what can you do, right? And then of course, there's always a plea bargain. He can possibly try to go for another plea bargain. But just as they're going to try to make an example of Derek Chauvin, the government is looking for people to make an example out of for rioting. right? They want someone to hold up and to basically put on a stake and show everybody what's going to happen to you if you riot again, right? So that's basically what they're doing. Of course, they're not going to talk about the fact that he had a firearm. They're just going to say he was right. The image that's going to be given to the public is that he was a rioter, and we prosecuted him, right? That's what's going to be given to the public, right? So he could challenge the constitutionality. He could look into vacating the previous judgment against him. He could ask the jury for jury nullification. And by the way, again, jury nullification is not a right, so actually he can't ask for it. He has to slip it in, right? He has to slip it in really quick. So maybe his lawyer and the closing statements can just say really fast after he said everything he wants to say. He could probably say, well, you as a jury has a right to throw this out whether or not he's guilty or not, right? You got to get it in real quick, because I think what can happen, or what I've read, is that if the judge gets a wind of what you're doing, he can stop it, right? And he can stop it because jury nullification isn't a right. It's just something that the jury can do, right? So that's it for this video. Leave your questions and comments below, and let me know what you think. Thanks for watching. Please like, share, and subscribe.